All right. Let's move forward to the initial interview with the client. And I've got a very practical question. When do you get the client's version of events? Do you get it or try and get it during the initial interview, or do you wait for later stages, wait for disclosure? When do you want to get the client's version?
I don't think there's any hard and fast rule. I think sometimes I've had cases where I got the client's version of events when he took the stand. Or at least the reliable version of events or the truthful version of events. I think in the post-Stinchcombe period, I think we've all learned a lot by just the concept of disclosure. And the same reason why we say to our clients when they're, if you're being arrested, don't say a word, don't answer a question. It's not because we're simply being obstructionist, but it's because the client may not remember well, the client may not know what they know, the client may not be apprised of all of the events and the disclosure information that will help him refresh his memory to provide you with an accurate version of events. That's why we say don't say anything. Wait till you know the whole story before you've said anything. Well, the same rule to some extent applies in your own office. If you're going to urge your client to tell you everything on day one, then it's very possible that that version is going to change over time. And that may impact upon your relationship with the client. The same way, if the client responds to the police and turns out to be mistaken, well, he's not mistaken, he's a liar. Well, in the same way, and perhaps not as harshly so, but in the same way, if you get as much information as possible at the first moment, before the client has had the opportunity to review disclosure, review the objective facts, try to fit in what in fact happened last Friday night or 5 Friday nights ago at 8:30 p.m. and where he was and what he was doing, that is problematic in terms of recollection until you have more information. At the same time, there are cases where you have to know certain features almost immediately because, as an example, if there's a possible alibi, or if there are witnesses who may disappear, or if there's evidence that may somehow deteriorate or be less helpful to you. You want to be able to establish that at the very first opportunity because you want to be able to follow it up and be on top of the investigation of the potential leads, or the potential witnesses, or the potential forensic evidence that will be useful to you. So there's a real balancing act, I think, in terms of what you get at that first interview. You don't, ethically and responsibly, it's really a problem if you say, I don't want to hear anything, and do the anatomy of a murder first interview, where you say, I don't want to hear anything. As I understand it, the facts against you are the following, and here are the following defenses. Now let's hear your story. And planting the seeds of the defense in that way really raise both ethical and practical issues, and certainly isn't the recommended, in my view, the recommended course of conduct.
I have a very simple rule. Somebody comes in and wants to retain me, as I said, somebody else is going to discuss fees, so I'm free to just have a solicitor-client conversation. There's nothing more sacred than a solicitor-client relationship. If you want to lie to me, lie to me. If you want to tell me the truth, tell me the truth. If I find out that you've lied to me, I'll come to you and say, look, it looks like you've lied to me. They'll say, I'm sorry, and then they'll tell you the truth. If you find a document later on, you put it to them and say, look, it can't be the way you said, because here's a document that puts a lie to it. Okay, fine, I'm sorry, and we'll try something else. The truth is ultimately what they testify to in evidence. Oftentimes, late in a cross-examination by the Crown, a different truth emerges. So I want to know in the first interview what their position is. I want to know for a lot of reasons. One of the main reasons is that I'm an irrepressible. I'm a gossip. I want to hear. I just want to know. I want to know because I believe the solicitor-client privilege means you can't tell anybody but your wife and your very best friends. And I live by that rule very, very much. But if I walk out of a first interview and somebody says, "Well, what's the story?" I don't know. I didn't ask. I mean, I can't. It's so against human instinct to sit in a room with somebody who's charged with a crime and not say to them, "Did you do it?" Okay? I mean, why? There is nothing that will affect or impact on your relationship. What, I'm going to get mad at somebody and say, "You lied to me, you SOB, I don't want to act for you anymore"? I mean, they're entitled to that. That's why the privilege is there. So that if they have to walk away from a position that is not going to work in the courtroom, they'll find out when the disclosure comes. But otherwise, I mean, how do you get retained by somebody if you found out what their story was, you may say to them, "You know what, this fee will be about $40, we should plead guilty today." It's irrelevant. It's irrelevant in terms of how you're going to position yourself, because Stinchcombe has now said you want the disclosure to make sure you're not embarrassing your client when he walks into a courtroom or yourself. I don't want to know it all. I want to know it all, and I won't let them leave until I know it all.
All right, we're running a little bit behind schedule, and we should take a break either now or shortly, but let me ask just one short question. It's about managing client expectations. So you've got the client, and the client is pressing you for assurances that they're not going to be convicted, or they're pressing you for assurances that they're never going to go to jail at the end of the case, and you know it happens to be a formidable case, and it's hard to give those assurances. How do you deal with that situation?
You give the assurances. I mean, what the hell?
Well, it's break time.
You can be right, you can be wrong. Look, I care enough about my clients as people, whether or not they're despicable people, whether I don't like them, whether people in my office don't like them. I think they're entitled to be treated well and courteously and decently, and I think that if they ask you a question like that, then you have to give them an answer. You can talk about ranges of sentence if they're convicted. You can talk about this, you can talk about that. You can tell them that the defense, who knows, may be viable, it may not. Many innocent people have been convicted. Many innocent people have spent years in jail before, and you can tell them all of that, to let them know gently that you don't know. And it's all a matter, you don't know who the trial judge is. You don't know what kind of a jury you're going to get. You don't know any of these things. But I walk them through the entire process so that at the end of it, they'll be comfortable in the fact that it's all a matter that will unfold as the case unfolds. And I've had clients who've pressed me, seriously pressed me. I can't answer those questions. And I tell them, but I'm not curt with them, I'm not short with them, and I think they're just entitled to the reassurance that I think any client's entitled to. It's very serious business when you're charged with a criminal offense, and it's very scary for them, and they're looking for some comfort, and they may be jackasses, these clients, but they're still entitled to your best opinion as long as it's honest. Has to be honest. Never ever lie to a client.
But also never try to fully predict even if you have a strong view of what the outcome might well be. I think that the best you can do is say the issues are arguable, the issues may prove successful, the issues, but again, the caveat that you don't know who the judge is, you don't know various things that could impact on outcome. And I want you to know something happened today. And I'm surprised that when I saw Enzo, he didn't express his sympathy to me today, because I lost something today that I will say publicly should never have been lost. I'm shocked by the outcome. And I assure you that my client asked me repeatedly what I thought would be the outcome. It's a case, an extradition case, decided by the Court of Appeal some months ago, which I had an incredibly strong dissent from Justice Sharp. It's the case of Barbu. The majority judgment
I
was...
sent you Barbu. You lost Barbu?
Because you had...
I sent you Barbu and you lost Barbu?
Yes. You had a conflict, Eddie. You remember that? We'll talk conflict afterwards. All right? Barbu... Barbu was McFarlane with McPherson in agreement with McFarlane in the Court of Appeal, a strong dissent from Sharp on a very, very interesting issue relating to the judgment of the Supreme Court of Canada and USA in Fischbacher. So it was an important issue. It was a novel issue. It was something that would impact on future extraditions. It was something that was tailor-made for the Supreme Court of Canada to take on. And the thought in our office was almost unanimous that this was a slam dunk leave. Okay? Today, when they dismissed the leave, who dismissed the leave? Sharon, who wrote Fischbacher. Deschamps, who you can always count on to be against you in a criminal case. And McLaughlin, who decided that she wouldn't differ from her two colleagues. A leave court that would have been Binney or Fish or Abella or, for that matter, a couple of others, would have almost certainly granted leave in this case. It's a tailor-made leave case. And so when John Joel Barbu asked us, well, what do you think is going to happen? All we could tell him was that we felt strongly that it was a very arguable case. It was a case that went beyond him. It was a case that is the type of case we thought the Supreme Court of Canada should take on for decision. But obviously, we don't know who the three judges are going to be. Obviously, there is nothing that is ever totally predictable, but we wouldn't be going further with this case unless we felt strongly that there was a real possibility of success. Those things we told him, right? And today, our Joe Makepeace of our office had to go out to try to console him at the jail as he goes on to the state of Pennsylvania for a trial that he shouldn't be facing right now.